When you've been sued by a debt collector like Midland, Portfolio, or LVNV, it's almost never a good idea to file a motion to dismiss. I'm going to tell you why, and I'm going to tell you what you should do instead so that you can beat your debt collector for good. My name is Mike Waslick. I'm one of the lawyers at Ricardo & Waslick here in Florida, and together with my partner Jason Ricardo, when debt collectors give you hell, we help you give it back. And today I'm going to tell you why you should almost never file a motion to dismiss a debt collector lawsuit by companies like Midland, Portfolio, or LVNV, and what you should do instead. The reason I'm doing this video is because so many of you in the comments have asked whether you should file a motion to dismiss in response to a debt collector lawsuit. Now, in my answers to those comments, I've almost always said, no, it's not a good idea. And so I wanted to do this video to explain in more detail why it's not a good idea and what you should be doing instead to win your lawsuit. So let's talk about what a motion to dismiss is, what it's used for, and why it's not a good idea in these types of cases. Now, as we go through a motion to dismiss, I want you to remember I'm talking almost always about Florida law and Florida rules. So if you're in a different state, different rules might apply, different laws might apply, and so the information in this video may not apply to you. But it's a good starting point for the research you may want to do on your own. But if you're in Florida, you're in luck because I'm about to walk through everything you need to know about motions to dismiss in small claims and debt collection lawsuits. So first of all, what is a motion to dismiss? That is a document you file with the court. It is a written request for the court to throw out the lawsuit based on some violation of rule, based on some failure of the debt collector to comply with the rules of court or the laws that are governing the claims they're making. It is almost always addressed to the original complaint and whether or not that original complaint meets the rules of court and whether it contains the information, the bare minimum information required for a debt collector to file that lawsuit in that way. So when would you normally use a motion to dismiss? When a complaint has been filed and you can look at that complaint and you can identify some way in which the original complaint fails to meet the bare minimum standard for what an initial complaint has to say. In some cases that's very common, in other cases it's not very common at all. And in debt collection cases it's uncommon, it's very unusual for a complaint to be so bad that it doesn't meet the minimum standards required for the type of lawsuit they're filing in court. Depending on the type of court you're in, the filing of a motion to dismiss might take the place of filing a written answer, and you wouldn't need to file that written answer until and unless the court decides that the motion to dismiss should be granted or denied. So why don't they typically work in debt collection cases, the types of cases filed by Midland, Portfolio, and LVNV? That's because the vast majority of those cases, more than 95% in my experience, are filed in small claims court, especially here in Florida. Instead, you have to show up in person or on video, depending on the court, and that is true no matter what document you may or may not file with the court before that date. And most importantly, in small claims court, because most people are usually unrepresented, the standard for what is a valid court document is lower than it might be in other procedures in the Florida courts. So a complaint filed on a debt collection case in small claims are going to be held to a lower standard, meaning a motion to dismiss is much less likely to have any effect whatsoever. One of those relaxed rules in small claims court is that the complaint doesn't need to attach a bunch of evidence to it. So you might think there's something missing from the complaint. You might think that there's a document that you want to see that they haven't put in their complaint, but the complaint is not something that requires them to attach all of their evidence. The complaint is simply a short and plain statement that gives you notice of what type of claim they're making against you and the basic facts of that claim. It doesn't need to include every little detail and it doesn't need to include every document. So if there's something you think is missing, a motion to dismiss is not the way to get that document or to get the case thrown out because the document isn't where you want it to be. Some people want to file a motion to dismiss because they think they have a good defense to the case and they want to raise that defense in their motion to dismiss and try to cut the case off really early. The problem with that is most defenses require the defendant to affirmatively prove them. You have to bring evidence into court. And if you think you've got a successful defense, a motion to dismiss is going to be a very difficult way of introducing your evidence in order to prove that you're entitled to get the case dismissed. So what should you do instead? Well, it depends on what you're trying to do and why. If you think you have a valid defense, something like identity theft, or this claim is beyond the statute of limitations, or possibly even I've already paid that debt, or it's not my debt. So instead of putting that into a motion to dismiss, you need to gather all your evidence and get ready for the time when you're going to present it to the court, usually at that final hearing at trial. You need to make sure that you have all your documents, you need to make sure that you have all of your witnesses lined up, and you need to make sure that you completely understand what the basis is for your defense and what evidence you need to prove it. And the good news is, because the vast majority of these claims are in small claims court, you don't have to give them any warning or advance information whatsoever. You just show up at trial and present it to the court. And if the court agrees with you, then the court is likely to enter a final judgment in your favor, meaning that the court has weighed the evidence and found that you were right and they were wrong. And that is so much more powerful than any kind of dismissal you'll get on a motion to dismiss. What if you think the other side can't prove its case? What if you think they don't have the evidence they need to prove that they're the right ones to collect the debt? Or maybe they can't prove that a debt exists at all. Well, then instead of raising that in a motion to dismiss and tipping off the other side, you're going to want to wait for trial and then see what evidence they produce. And if you're right at the end of trial, you'll get to ask the judge to enter that final judgment in your favor. And that means that the judge has weighed all the evidence and found their evidence lacking and your evidence more persuasive. And again, a final judgment, one that indicates that the court has weighed the evidence and found your case better than the other side's case and made a decision that you're entitled to win because the other side doesn't have a case at all. That's going to be so much more powerful in anything else you try to do after that debt collector's been booted out of your life. Now, what if you want to move to dismiss because you think the debt collector has broken the law in some way? Let's say you've watched some of my other videos and you've identified some way that you think the debt collector has broken the Fair Debt Collection Practices Act or some other law that applies to this particular debt collection claim. Well, in that case, you're not looking to raise a defense and you're certainly not challenging the sufficiency of their complaint. What you are doing is you are actually asserting a counterclaim. And that means that you do have to write up what it is you think the debt collector did wrong, why it breaks the law, and why you're entitled to relief. And if you do that, there's two separate claims that the court needs to weigh. First of all, did the debt collector prove its case that you owe a debt that hasn't been paid, that it has the right to collect? And secondly, did you prove your case that the debt collector somehow broken the law? And then the court has to decide, given those two decisions, who goes home with a check and who doesn't. But here's the great thing about these counterclaims. If you think the debt collector has broken the law and you're right, and there's a legitimate violation there that you can sue the debt collector for, almost always you can get a lawyer for free to sue that debt collector for you, put money in your pocket, and negotiate a complete dismissal of the case that wipes out your debt, removes it from your credit report, and puts money in your pocket. And that is so much better than a mere dismissal of the case. It's a total victory over your debt collector, and it's something we're always looking for in every case that comes across our desk. So if you have affirmative defenses like identity theft or statute of limitations, you're going to want to bring evidence to court on the day of trial and ask the judge to enter a final judgment in your favor. If, after trial, you think that the other side has failed to prove some essential element of their case, again, you're entitled to ask the court to say that it weighed the evidence and enters a final judgment in your favor, meaning that you are the victor. And then lastly, if you think your debt collector has violated the law, then you're entitled to counterclaim. And if you have a legitimate violation of the FDCPA or some other law, then you're going to want to file that counterclaim, and you're probably going to want to talk to a lawyer because your lawyer will be free. So how do you know which of these applies to your case? Well, if you want to know a lot more detail about how to break down a complaint by a debt collector like Midland, like LVNV, like Portfolio, I want you to watch the video I'm putting on screen now, because I walk you through the steps of how to break down the accusations against you, what is there, what isn't there, and how you can use it in your favor to win your debt collection case for good. So if you want to know more about how to win your case, go watch that video. But thanks for watching this one, and I'll see you on the next one.